Good afternoon. I'm attorney Catherine Henry, and I promised you guys earlier today that I would do a Facebook Live video to describe what happened in today's court hearing between the legislature and the governor's office. And so I finally had some time to break away from answering questions on other things. So this is that update right now. I do have some limited availability to be able to answer questions in a contemporaneous manner. So if you want to try to send me a question in the comments section here, I promise that I will try to get to that question, but I may not be able to see every single comment and question, and so I just can't guarantee you that I'll be able to address everything that's written in there. So, to bring you guys up to speed on what happened today, I don't remember exactly what time it ended, but I want to say starting at 10 a.m. this morning, 11:30 this morning, there was a hearing that was conducted by Zoom. There were 4 people present. I'll identify them in a minute. And that Zoom meeting was then broadcast on YouTube, and I shared the link earlier. I do believe you'll be able to still click the same link and go view it in its entirety after the fact. So the case that was involved is the legislature's lawsuit against the governor for her exercise of emergency powers after April 30th. The people involved, oh shoot, I didn't even write down the judge's name. Let me see if I have that here. Judge Cynthia Stevens is the judge assigned to this case. She is she's serving in the capacity of a court of claims judge, which is a unique part of our court system. It's essentially like a trial court. For the most part, follows the rules of circuit court proceedings, like any other, property lawsuit or something that would take place in circuit court, but it's actually housed within the Court of Appeals. So the people, there's a lot of different attorneys involved in this case, but the 2 attorneys that, well, aside from the judge, the second person present in that Zoom meeting was actually the court recorder, and she's the one that will end up doing the transcripts from the hearing. The last 2 individuals that were present were Michael Williams. He's actually employed through a private firm, but he is listed as counsel, lead counsel for the plaintiffs in this case, so for the legislature in this case. And Christopher Allen, who I believe is actually employed directly with the Attorney General's office, and at least in this capacity has filed pleadings indicating he's filing the pleadings through the Attorney General's office on behalf of the governor in this situation. So today was not necessarily meant to resolve the entire case. Officially there were 4 motions that that were essentially handled today. So the first one, and one that I'll go into a lot of detail on later, is the let's see, I'm saying exactly the way they titled it here. The legislature's motion for immediate declaratory judgment. And that's what I'm going to be spending most of the time in this Facebook Live video talking about and explaining what happened. But it is important to note the other aspects that were ruled on today. So there was also a motion to intervene. That was filed by, I believe, 5 different attorneys who are in practice throughout the state. Some do civil work, some do criminal work. And essentially what they were asking for is to be joined in as essentially an additional plaintiff, that they have claims against the governor for her using these executive orders, these emergency power executive orders, and that because the vast majority of the issues of fact and of law that were filed in the main action, or in other words, the lawsuit filed by the legislature, because those issues of fact and law are largely identical to the ones that these 5 attorneys, these interveners, that their lawsuit, had they filed separately, that those cases would be essentially parallel cases to a large degree. Most of the same, if not all the same fact, and most, if not all of the same law on point. So what they did is they're basically saying, for the purposes of judicial efficiency, why don't we join in as additional plaintiffs in this case? So we can represent our interests, the legislature can represent their interests, and we're addressing the exact same things. The judge decided to not grant that motion today, not saying that there was no validity. I believe she even essentially complimented the intervener attorneys for their work on their brief and the points that they raised, but she believed that with all of the other briefs being filed in this case, that the legal issues were being sufficiently sorted out through those pleadings. So she did not allow them to intervene. One thing I should make perfectly clear is I did not hear every single word for word, that was said throughout the hearing, because while I had it up and running, I was simultaneously trying to answer people's questions on the my earlier Facebook post about the hearing. So I was trying to answer questions while listening to this, and I may have missed a statement or two. I will be going back to view the whole thing a little bit later. That brings the additional motions that I mentioned before that were also addressed in addition to the main motion. There were, as of, I want to say 4 o'clock yesterday, I believe, there were only 2 motions filed by separate parties to be able to file an amicus brief. And that's essentially where someone is saying, I don't necessarily want to intervene and be considered an entire equal party to the main plaintiff and the main defendant, but I have something to offer to the court in being able to sort the issues out. So the 2 that I was aware of were the ones filed by the Michigan House Democratic Caucus and then the Michigan Senate Democratic Caucus. And they were actually filed as separate motions with apparently separate but similar interests. And those, like I said, the purpose isn't to try to intervene completely throughout the whole proceedings as though they are an additional or separate party. But as the counsel for the Senate Democratic Caucus explains, they believed that they had some special institutional knowledge that would be of assistance to the court in reaching the proper resolution in this matter. So that's essentially the purpose of having an amicus brief filed. So I was surprised to hear, though, this morning that the judge said that there had been essentially a bunch of other similar motions filed by other parties or other groups later on in the day, and in fact there had been even more than what she had seen at last time she had checked. So my understanding is that all of the motions that have been received by the court thus far to asking for leave to participate and be able to file an amicus brief, those were all granted, allowing each of those briefs to essentially stay on record and allow the court to sort through the issues in determining how they're going to rule. So that brings us to what happened today. So like I said earlier, today's motion was for immediate declaratory judgment. What that essentially means, to try to pull the language right from, is that they're asking for immediate relief because the governor has gone so far outside of her bounds of statutory and constitutional authority that the judge, essentially as a matter of law, can just look at the situation and the facts that are undisputed and be able to determine that yes, in fact, she did go beyond those bounds, and it is impacting nearly 10 million lives without the consent or input from the people's representatives, the legislature. So they are asking for not only the court to resolve this, but to resolve this essentially immediately because of those huge implications. So, do I know for sure which way the judge is going to go on this? No, because she did not give a hearing while she was on, she did not give a ruling while she was on the bench. But what I can tell you is that if she decides to deny the motion for the immediate relief, that does not mean that the legislature's case is essentially being thrown out. What that means is she has decided to allow the normal court process to continue, in theory, all the way through a typical trial, to have witnesses and exhibits and oral arguments and testimony, and essentially have an expanded mechanism for allowing all the documents and testimony on point to be fully developed on the record. If she does grant this motion, it means that this case is over at her level, and the only way the case continues is if the governor's office, if either party wanted to appeal and they go to the Supreme Court, then the case would continue, but just at the next level of court. So if she denies the motion, it doesn't necessarily mean that that's, the whole case is a done deal. It doesn't necessarily mean that it's the worst situation for, what the long-term outcome of this case is going to be. It just means that she has decided she just wants to hear a lot more on this case before she renders that determination. So I think that answers the question about procedurally what was being addressed today. Did we seem to have any questions so far just about the stuff I've covered so far? So, what would that look like if the judge in this case decides she's going to grant the legislature's motion and issue the immediate declaratory judgment rendering the exercise of emergency powers after April 30th as null and void? What does that look like? In theory, the most reasonable outcome would be that would essentially require the governor's executive orders to be paused or to not be enforced while the case is pending. Now, if the governor's attorneys decide to file a request either at that level regarding possibly a stay from that same judge, or they go ahead and they file an appeal at the Michigan Supreme Court and then they ask for a stay at that level, what they would be asking for is for the court to say, we understand that this judge has just said what we're doing in the executive branch is not enforceable now after April 30th, but we're going to ask that you pause enforcing that ruling or that order until we can have the Michigan Supreme Court sort these issues out. So that could happen. My guess is that if the judge in this case does grant the motion for immediate declaratory relief, she's likely not to allow the governor's office to have a stay granted, which would keep her executive orders going in the eyes of the court. Because essentially what she would be saying is, we recognize here in the court that the executive orders have no legal authority after April 30th, and it's directly infringing upon the rights of the people, as well as the rights and responsibilities of the legislative branch, and that must be stopped immediately. So going forward, no matter who appeals, we need to have those issues corrected. That would be my best guess as to if that were to happen. But again, there's so many pieces here, and there's no guarantee of any particular thing occurring, so don't take any of what I'm saying right now as a promise of how this particular judge is going to rule, or on how the Michigan Supreme Court is going to rule, or on what any of the individual attorneys are going to do. So let me see. So when an amicus brief is filed, we have a question here about, well, what is that? That just goes back to what I was explaining, that it's an outside person, a person or a group of people or an organization that is not already in the case. So it's not the plaintiff, it's not the defendant, it's an additional group or individual that believes that they have something to offer to the court in sorting out the issues involved. So it could be perhaps if a lot of times at the Michigan Supreme Court, when they invite briefs for these situations to be filed, it might be a criminal case that is being appealed, and there might be an issue about some sort of criminal procedure. The court will often ask the state bar various sections, like the criminal defense section, or a group of prosecutors to weigh in from their perspective with any additional information that they might have on the point to help flesh out all the issues involved. Now, those groups, that division of the State Bar of Michigan or that group of prosecuting attorneys, they are not coming into the case as full parties of someone's, appeal of their criminal conviction, for example, but they are coming in as essentially a friend of the court. Not friend of the court in terms of how we do child support and custody here in Michigan, but a friend of the court to just offer information to that judge or to the panel of judges involved, to say, listen, we have additional information you might want or you might need in order to sort these issues out in a way that has not been quite presented by either of the parties so far. They do have to stay on point to what the main topics raised by the two parties are. They can't just essentially kind of create their own new lawsuit and their own new cause of action to pursue, but they are allowed to bring in new legal analysis or new facts to help the court sort out the issues that are already before them. So when do I think we'll hear from the judge? Yep, I'm going to get to that in just a second. If she agrees and the executive orders are stopped. So if she agrees with the agreements, with the arguments that were made by the legislature's attorney today, then it's not necessarily the case that she's going to immediately issue an order requiring the executive orders to not be enforced. My best guess is that that's what she'll do, but she could act in a variety of different ways. It just depends on what her total findings are with the whole legal analysis picture. But in general, I would think the most likely alternative is if she is going to side with the the arguments made by the legislature that these executive orders are no longer legally enforceable after April 30th, my guess is that she'll issue an order that requires those to be immediately stopped from being enforced by any member of the executive branch, any law enforcement official, any prosecuting attorney, the Attorney General's office itself, etc. Long-term process. I think I'll be getting to that in just a second. Won't necessarily affect the current stay-at-home orders. Okay, so if the judge everything that we're talking about right now absolutely affects the current stay-at-home orders, because every single executive order that she has issued to this point, which I believe, as of sometime yesterday, I want to say that there were 88 executive orders now issued. I know there were at least 84, but I think by the end of the day yesterday, there might have been as many as 88. It's an insane amount. We're talking about all of them. Every single one of those orders that starts Executive Order 2020-, every single one of those that has been issued this year in 2020 is based upon her emergency powers. Those emergency powers are the very thing at issue in this court case. Some of the other, so the governor is being sued, by my last count, in 16 separate lawsuits from various organizations, various individuals in different courts. They all kind of have the same subject matter. They're talking about one aspect or another of these executive orders. However, the legislature's entire lawsuit is premised on the fact that there's entire emergency power ended April 30th. So, and that is the law. I mean, it did. It ended April 30th. And so once that emergency power ended on April 30th, none of her executive orders were legally enforceable, because the order that tells us we have to stay home, the order that tells us we can't really participate in, public meetings like we should be able to under the Open Meetings Act, the order that allows governmental agencies to not comply with the Freedom of Information Act, the order that tells us we need to wear masks in stores, the order that tells us that certain businesses can open but other ones have to be closed, the order that prohibits us from seeing our loved ones in long-term care facilities like nursing homes. All of those orders are based on the emergency power. So when that emergency power ended, all of those executive orders went away. The only way they were in place is based upon this emergency power that the governor had. So when that emergency power is gone, none of those orders are in place at all anymore. And that's already the state of things. We did not need to go to a court to have that part sorted out if everyone, including the legislature and law enforcement and individuals, had simply acted according to the laws and the Constitution provisions on point. We wouldn't have had to wait to go to court to have this sorted out. In fact, that's why I've been encouraging people, if you're a business owner, go ahead and open your business, because the law says you can. Certainly the Constitution says you can. So at any rate, that's, yes, it's all of those orders. I believe that answers that question. So we need to talk then about the issue of licenses. I'm going to come back to that one because I need to address specifically what happened in this hearing. So I'm going to circle that, and I'll have to come back to that one. But so as far as what happened today, the judge essentially asked the court staff to how long it's going to take to be able to get the transcripts ready. She's just thinking ahead. This judge is just totally thinking ahead to the next step, because she does not need to wait for the transcripts to come in order to issue her order. However, she did, and I'll tell you why in a second. So the court reporter said that it would take her, basically she can do it whenever. So knowing that it's a Friday, and then of course Saturday and Sunday they're not required to work, The judge essentially asked her to have it ready. I believe she said Tuesday morning, at least sometime on Tuesday, but I think she said Tuesday morning. So the transcripts will be available and ready then. Does that mean they're going to be released to the public? That is a whole separate issue, which we should talk about. I'm going to actually make myself a note to get into. No, most likely not. Most likely the public will not have access to those transcripts. But they will be prepared and available. Why the judge wants to do that is she knows as soon as she issues that decision, it doesn't matter who loses, they're going to want to appeal. And so when they do appeal, the appellate rules require transcripts from the lower courts to be included with all that documentation that gets sent up to the next highest court. So, like I said a moment ago, she's thinking ahead. She knows that because someone wants to appeal, they're going to need the transcripts at the same time. So, my assumption is that the judge will probably issue her decision Monday, or maybe wait till Tuesday so that it's all done at the same time. She might wait for confirmation that the transcripts are in fact completed before she issues her order. And so the next steps, like I just said, no matter who loses, most likely, no matter who loses, that losing party is going to appeal to the Michigan Supreme Court. Certainly, if the legislature happens to lose, my assumptions based on everything I've seen and heard so far is that they would appeal, and they should appeal, and that they would likely prevail on appeal. But let me go into what I actually saw throughout the hearing. Let me see if there's any questions I have to answer first. Okay, so I answered that. Okay, and I already did kind of answer this, but some of you might have been tuning in and not heard the answer. So if this case goes to the Supreme Court, so if the losing party decides to go ahead and appeal right now, does that mean the executive orders will stay in place until a decision is made? It totally depends on who loses and what essentially has been ruled on at the Court of Claims level. So if the Court of Claims, if the judge we've been talking about, if she has Monday or Tuesday, she issues her decision that says, I agree with the legislature that the that the emergency powers ended April 30th. Therefore, all actions resting upon that authority that have happened after that are null and void. And so therefore, if she's going to grant the legislature's motion for immediate declaratory relief, then most likely, if that's the case, then she's probably going to issue some sort of order that's going to suspend the enforcement of any of those executive orders, because she's already going to find them illegal and unconstitutional. So why would a judge not require the government to stop immediately enforcing any illegal or unconstitutional orders? I'm guessing she's going to do that. If she finds in favor of the legislature, if she finds in favor of the governor's office and denies the motion for this immediate relief, it does not mean she's necessarily saying that the governor has been allowed to issue these executive orders and to continue exercising this emergency power after April 30th. It depends on what her analysis is and what the wording of her order is. But in general, she may very well still think the governor has done wrong, but she might believe that there's some sort of need to keep the case going in this trial court level to flesh out all the issues. My assumption is that, well, I'm going to jump ahead of myself. I'm not going to go there just yet. Let me see if there's other... okay. So I think we addressed that. if they forget about protocols. Ooh. I'm going to have to ask for follow-up. Whoever asked the question, what happens if hospitals, police officers, child protective services workers have forgotten about protocols because of COVID-19? Whoever asked that, I'm not sure exactly what you're getting at. If you're getting at the fact that they've been brainwashed for the last 2 months to allow the government to run wild and totally ignore all of our statutory and constitutional rights, that'd be a big question to answer. But if that's what you mean, just try to, I guess, let us know that or clarify if that's not what you were asking. So why is she ordering law enforcement to go after people disobeying? I'm not sure. Was this question, did they say the word she? I'm assuming the question is getting to why the governor or the Michigan Attorney General is requiring law enforcement to go after people. The Attorney General, Dana Nessel, did issue guidance to law enforcement, I believe it was May 4th, explaining to them that they have to enforce these executive orders. Why did she do that? That is a very good question, because I honestly think that woman is way too smart to believe in the argument she wrote to law enforcement. It is so incomplete and inaccurate. Literally, the whole thing she's saying is you have to enforce these executive orders because of the 1945 Act. We don't even have to bother with the 1976 Act. We can just focus on the 1945 Act. And when we're doing that, essentially the only thing required of the governor is that she issues orders that are reasonable to address this COVID-19 crisis. First of all, I would argue and have argued in that 11-page letter from my response that clearly these executive orders are not reasonable, no matter how you look at it. But that's not even what the law says. Yeah, it requires the orders to be reasonable, but that is literally like one tiny little word or one little phrase of the whole statute. So I think the Attorney General is way smarter than that. I think she knows better. Why she would issue such an edict to law enforcement across the state, I have no clue. I really don't. How does she have the right to take Carl's license? We're going to get to licensing in a minute. The short answer to the question of how does she have the right to take Carl, the barber's license, she doesn't. They absolutely have zero legal authority to do that. But we'll get into that specifically in just a minute. Okay, so I think I got all those. So let me tell you then what I took from this watching the hearing. I tuned in at maybe, by the time I got my links like working and everything, it was probably 10:02. But they were already, it seemed like they were already in full force, like they were already in full swing of this hearing. They had definitely already identified themselves and whatnot. Like I mentioned before, oh, and in case you're just tuning in, I'll mention a couple things real quick. I missed that first 2 minutes. I had it on all the way through. However, I was simultaneously trying to answer questions that people were posting right on Facebook to me about what was going on and what the hearing is about. And so I was kind of multitasking with that. So I definitely may have missed some statements or some comments made by either side or the judge. It's possible. But what I did hear, I heard and I was definitely paying attention to. So to briefly recap, it is Judge Cynthia Stevens that is presiding in this matter. She is serving as the Court of Claims judge assigned to this case. It's not a panel of judges. It is one judge. She's essentially serving as a trial court judge. Even though this Court of Claims entity is like sitting in the Court of Appeals, it's still treated more like a circuit court judge. And I believe there's 4 of them, and they rotate on who takes different cases. So she is the one that was assigned at this exact, for this purpose. And the 2 attorneys that were doing the oral argument on behalf of the parties today were Michael Williams. He is actually from a private firm, but he is the attorney that was arguing on behalf of the legislature. And he, by the look of his P number, his attorney registration number, is a fairly new attorney. My guess is maybe 3.5 years ago. I want to say his P number started 7900 or something. And then Christopher Allen was arguing on behalf of the governor. And if I read everything correct, my understanding is that he actually works for the Attorney General's office, one of the assistant attorneys general. And if I remember right, he actually, based on his P number, was probably sworn in. When was I sworn in here? He was probably sworn in 12 years ago, probably 2008, because his P number is very close to mine. So let's see here. For what it's worth, I was sworn in Minnesota before that, but so at any rate. So those are the two attorneys that were making the arguments. Michael Williams, let me back up and say I don't know these guys. I don't think I've ever met them at any, legal functions or bar association meetings or anything of the sort. Maybe I have. I'm not speaking to that though. So I'm just speaking to how they did in the oral argument today. So Michael Williams, by and large, answered every single one of the judge's questions. We're attorneys. So did it take him a long time to answer the questions sometimes? Yeah, but he answered them. And I do believe he answered them for the most part very succinct, or not succinctly, but very clearly. Very on point. He seemed to know the cases or know the statutes, know the constitutional provisions, more or less on the top of his head. He made just some really great points, and overall he did an amazing job. He's human though, so there are a few things that I believe could have been emphasized a little bit more, but we can go into that in a minute. Christopher Allen, again, I don't know him, seems like a great guy. Quite honestly, he seems very intelligent. However, in his oral argument, he did not really answer the judge's questions, and she repeatedly would end up interrupting him or commenting to say, "That's not what my question is. Could you please answer my question, which is this?" I think he was trying his best, but honestly, I think he's got a really bad argument on his side. It is very clear what the law is here. So he fumbled through quite a few of the explanations, definitely fumbled through answering the pointed questions that were brought to his attention. But they, again, unless I missed something, these two guys remained professional the whole time. They were civil. It's not like anything got personal or ugly between them. They, overall, as professionals, they did a great job. And I'm not trying to insult either one of them, or their legal skills or their intelligence. I think they are both intelligent attorneys and professionals, based on what I saw today. But as far as how I think it played out, I think this judge, I think she's smart too. I'm going to be honest, I don't have any personal experience with this judge. I know that she's made some bigger kind of recent decisions on some cases, but I don't have any personal knowledge with those cases. They just weren't things that I was working on myself. But she seemed to really hone in on what the statute actually says, what the Constitution actually says, and what they don't say. So she seemed to apply common sense. She seemed to see through a lot of the stretch arguments that were made on behalf of the governor. She, honestly, in some of her questions, seemed to kind of clarify and help Attorney Williams in making some of his statements. And at one point, he so astutely made the comment that, well, Your Honor, you just pointed out exactly why you're on the bench and we are not, because you made my argument sound, essentially much more clear and concise than what I was trying to say. But that what you just summarized is exactly what I was trying to say. So the judge, when it came to Attorney Allen's points, I don't know if he was necessarily trying to mislead the court or if he's just doing his best with the worst set of facts and law that he could have on his side. But as he's dancing around things and not quite, addressing a point or answering, she was calling him out on it. And she was, and not in a attacking kind of way, but in a, let's get to the point. This is what I asked. What about this? In fact, at one point, he's going down a particular argument, and she says, quite frankly to him, that's about the worst argument you have so far in this hearing, so you might not want to continue making that argument. So she, my take on it is she knows what the law is. She knows the governor does not have these powers. She knows that if the executive branch, which is what the governor's in, if the executive branch is allowed to exercise this emergency power in such a way to issue executive orders that have the full force and effect of law, and that she's doing so in a way that is erasing statutes already on the books, that's a problem. That's a problem with the separation of powers. That's a problem in a variety of aspects. Now, I want to be clear that the emergency powers, some of our statutes on the books put restrictions on the people. Some of our statutes on the books, though, put, restrictions upon governmental agencies or entities. So, for example, in one of the executive orders that the governor has issued, I don't remember which profession it was. I want to say there's one involved for the medical professionals. So we have in place a ton of regulations and laws on the ability of medical professionals to treat patients. And one of her executive orders specifically said that it was essentially releasing or loosening some of those restrictions to enable more medical professionals to come in and be able to treat patients. So, for example, I believe that, say, a nurse, nurse practitioner, an RN, I'm not sure, if it applies to both or whatnot, but a nurse, say, coming from Wisconsin, who, Wisconsin doesn't have the level of COVID-19 cases that we do, that nurse could essentially come over to our state and continue in her same medical profession, but without jumping through all the normal hoops of transferring that license. So in a sense, it's taking away the restrictions upon the people. That kind of thing, I believe, is the main point of, and it actually talks about it in the language of the the Emergency Management Act of 1976. One of the statutes specifically talks about loosening restrictions and things. So I believe that's one of the main points as to why the governor would be allowed to have this emergency power. The emergency power isn't so much meant to put more restrictions upon the people, but instead it's meant to be able to allow the governor to gather all kinds of resources and, in attempting to do so, loosen the restrictions upon the people. So, saying people are not going to be charged with driving on a suspended license during the time that she has closed the Secretary of State's office, right? So those kinds of things are the very thing that is, I believe, permissible, essentially reducing the amount of government restrictions. So in the sense that these executive orders are being used to place far too many restrictions upon the people, additional restrictions that have not gone through the proper legislative process, and that certainly at least many of them, violate constitutional provisions from both our state and United States constitutions. That's where I think this judge is. She seemed to catch on. She seemed to understand exactly what the legislator's attorney was trying to argue there. In fact, at one point she asked questions about, well, if we take your argument, meaning Attorney Allen, who is working for the AG's office and representing the governor, if we take your argument, Attorney Allen, then wouldn't that mean that the governor could essentially continue through her whole term of office under one big, exercise of emergency power, one state of emergency? If you think that she can continue to extend it in perpetuity, I would argue, based on what she's done with election law, that she would attempt, if that were the case, she would then also attempt to postpone the elections themselves, allowing her own term of office to extend beyond the years she's otherwise allowed to serve. So, at any rate, I think it goes to the very insanity of some of these arguments and why it doesn't work to say the governor gets to just do these things unilaterally. Trying to remember one of the other good points that was made there between the questioning between the judge and the attorney for the governor. He was talking about the Emergency Management Act, specifically MCL 30.403, and he seemed to be suggesting that there were the provisions of subsection 1 and 2, essentially the first and second paragraphs of that statute, somehow gives the governor broad powers, but subsections 3 and 4, where it's defining her use of emergency powers under a state of disaster and a state of emergency, that somehow those are specific, but she was exercising the powers under the first two portions of that statute, which is a general exercise of emergency power. I don't know if he just got tongue-tied or whatnot, but that didn't go very far. There was another argument being made about what, in terms of addressing the separation of powers argument, if she was essentially asking Attorney Allen, if you're saying the governor can just go ahead and continually issue these executive orders of a state of emergency on her own without the legislature's approval, how does that not violate the separation of powers? And they were getting at the point of, in the questioning back and forth, who essentially gets to step in to provide the checks and balances in that exercise of power. And, of course he's saying, well, it's not the legislature, they don't get to do that. So, okay, well, if the legislature doesn't get to do it in the exercise of their own actions, then they don't get to then stop her, in any other way. The only thing I guess they could do is file a lawsuit, which means it's actually more of the judicial branch that would be putting a stop to her. So his answers were pretty clear that the legislature does not get to stop her at all from using these executive powers, these emergency powers. And so then the questioning became, well, she was asking him, are you saying that a private citizen then would be, it's up to them to file a lawsuit in the court of claims, bring it to the judicial branch to essentially put a stop to it? I think he eventually said no to that question, but she asked him multiple times, and his answer was not straight and to the point. So I'm not sure really who he thinks provides the proper checks and balances if his argument is true that she gets to keep exercising these emergency powers beyond what the legislature has approved. Before I forget, one point that I wanted to make that I think the legislature's attorney, Mr. Williams, didn't stress. I didn't hear him even mention it at all, actually, in oral argument today. I might have missed it, but it's truly an important point. So they did talk a little bit about um, MCL 30.417D, and how the language there says that the Emergency Management Act, which is that 1976 set of laws, shall not be construed to limit, modify, abridge, or abridge the authority of the governor to proclaim a state of emergency pursuant to the Emergency Powers of Governor Act, or essentially MCL 10.31. So the funny thing is, so what I just did to you was I read the statute. I mean, I read it word for word, except I cut out essentially unnecessary parts or irrelevant parts, because there's it's saying that the Emergency Management Act shall not be construed to, and then it lists actually a couple different things, and so the ones in between we all agree are not relevant there. All attorneys on all sides of this issue, but and so it brings you down to the next point. So that's why I left out certain language. When he left out certain language, he actually left out the word proclaim. So listen for proclaim. So the Emergency Management Act shall not be construed to limit, modify, or abridge the authority of the governor to proclaim a state of emergency pursuant to 10.31. So this is the important point that I don't believe Attorney Williams addressed. Like I said, unless I somehow missed it, maybe he went through it kind of quickly or something. But so that's kind of the governor's whole argument, is that, well, one of her main arguments, right? She gets to use MCL 10.31. She gets to use the 1945 powers without being constrained by anything in the statutes from 1976, because according to her, the 1976 statutes cannot place any restrictions upon her use of the power under the use of emergency power given to her under the 1945 Act. That is the argument. However, it says that the 1976 laws cannot be read to limit the authority of the governor to proclaim a state of emergency. It doesn't talk about the full use of, what using those powers looks like. It's talking about the initial proclamation. So she did get to issue an initial proclamation. She did so on March 10th of this year. And so the everything in the Emergency Management Act of 1976, every single piece in there, none of that changes her ability to proclaim a state of emergency. In fact, Michigan Codified Law, MCL 30.403, it actually bolsters her authority to proclaim a state of emergency because it gives the proclamation full force and effect of law, which the older 1945 Act does not do. So basically, when she issues an executive order based on these emergency powers, under the 1945 law, it doesn't spell out that that executive order then would have the full force and effect of law behind it, whereas in the 1976 law, it does. So I don't know how we can view it any other way than to say, well, the 1976 law bolsters her ability to proclaim that that state of emergency because it's giving full force of law to such a proclamation, to such an executive order. And so, additionally, MCL 30.405 adds, quote, additional powers of governor in these situations. So again, we're giving her additional power, which I actually don't agree with that statute at all, but that's a different point. So in that statute, it's giving her additional power that she doesn't have under the 1945 Act. And then in MCL 30.402, subdivisions E and H, we are adding additional circumstances which may qualify for the exercise of these emergency powers, because the 1945 law has a very specific list of situations that it's referring to. The 1976 law in the provision I just mentioned, has a whole definition section. And in the definition for disaster, I mean, it spells out quite a bit more. And then you have the additional provision in subsection H of that statute that gives the kind of like a catch-all definition or description of what state of emergency would be. So, if anything, the 1976 Act totally expands upon her ability to proclaim a state of emergency or state of a disaster. It doesn't do anything to stop her from proclaiming one. So what it does is it says the duration of that must be essentially stopped at 28 days unless the legislature agrees that she needs to exercise those particular police powers in order to get this emergency under control. And they did do that here, but they did not extend it past April 30th because they can do that as a collective effort that's done through the normal system of checks and balances, where if any laws need to be amended, they can be done so through the proper legislative process, and they can be signed by the governor as is required, or brought back to the legislature for passing it pursuant to the procedures after a governor has vetoed a particular bill. So those things can still be done, and the legislature has been meeting and can meet and can continue to meet to do that. Or better yet, we can recognize the ability of the local authorities, or even better yet, the local care providers. Let the hospitals make their own decisions on how many beds they need to reserve for COVID-19 patients. Let the nursing homes or long-term care facilities determine who should actually be admitted to their facilities to in all of this. Should they be taking on COVID-19 patients when their whole population is essentially the most immunocompromised individuals we have in our state? They should be the ones, the nurses and doctors treating those patients should be the ones making those decisions, not some, bureaucratic system of, a bunch of red tape, a bunch of top-down decisions being made by a governor or even Dr. Khaldun, who's not capable of knowing the individual needs across the entire state based on differences in region and how this thing spreads, or based on different facilities and the ability of that facility or of that physician or team of medical professionals to meet the needs of the patients that they serve. She certainly doesn't know anything about particular patients and what they need, so except for the ones that she's treating. So essentially that's, we don't need these emergency powers to be, these police powers to be used in such a way, because if a law needs to be changed to address this, that's what the legislature is there for. And otherwise, we need to rely on the people to make appropriate decisions, or the local authorities, if appropriate, or the actual medical professionals or other professionals involved to be able to treat their clients or their patients or their customers in such a way that's best for them. So that's essentially, that gets to really more of the idea of why we don't need to have these emergency powers in place. But again, the whole point that I think was missed is that 30.417D, the only thing it does is it hinges on this new law, this 1976 law, cannot be interpreted or exercised in such a way to stop the governor from issuing a proclamation of a state of emergency, which she did. And that 1945 law does not allow her to issue multiple states of emergency for the exact same situations that led to the state of emergency in the first place. The 1976 law doesn't allow her to do that, but the 1945 law doesn't allow her to do that either. What sense would that make? You issue the state of emergency for the time being to enable the governor to employ all the emergency forces to basically collect and to reorganize her own department, essentially, to be able to collect all the resources, to be able to relax the governmental restrictions upon people and upon certain professionals, to be able to treat that specific need. But then when it becomes something that's not an emergency, it's something we can deal with in the normal course of business, then we need to be able to go back to the normal course of business. And so even the 1945 Act acknowledges that. So the argument that she gets to keep issuing these new proclamations of state of emergency, this isn't something that she can just, in fact, I think Attorney Allen was arguing in defense of the governor that it's basically a matter of paperwork. And so she followed the 28 days, she ended that state of emergency, she issued a new state of emergency, and she's entitled, in fact, she has a duty to keep issuing these states of emergency for the same exact situation. So that it doesn't make any sense. This isn't a mere term of art to be used and abused. A state of emergency is what it is. It's defined clearly in the statutes. It is meant to address a specific thing that needs specific and acute government action for a limited period of time, simply to bring it down to a point where it's manageable under the normal procedures involved in our government. So, at any rate, that's one of the main points I thought was missed. There might have been more. I did find it kind of interesting and amusing, I guess you could say, that some of my very analogies and ways of addressing this that I've published in the 11-page document that I've shared with all law enforcement and prosecuting attorneys across the state, that I've posted online on Facebook and on stopcovidchaos.com, that some of the very arguments and analogies that I used in there, he actually used today. So when Attorney Williams was talking about the governor issuing these executive orders or issuing these states of emergency and then terminating them and then continuing them and then issuing them, first of all, it doesn't even make common sense, but he referred to it as the light switch being turned on and off, on and off. And that's exactly how I had described it to people before. So it was good to see that there are attorneys out there. I've been, as far as I know, the only attorney in the whole state of Michigan that has been vocal in explaining what the law is and why she doesn't have the right to do this. I know there's other attorneys that are on the side of this issue, same side of this issue, but I have not seen or heard of any other attorneys literally across the whole state who are going out there and willing to kind of explain it to the public or to law enforcement that way. So it is super refreshing and awesome to hear that there were attorneys that are vehemently arguing for the statutes and constitutional provisions to be upheld as they are written. So to see if I answered any more questions. The girl that also asked for follow-ups. Okay. I'm assuming I don't need to do anything with this. Okay. So, what would it take to get the result that Wisconsin did? I'm going to be honest. Let's see, where is that? The Wisconsin decision that came out, this right here, double-sided, this is about 86 pages. This was half of the whole document. Now, granted, I only printed the actual order and the concurring opinions of the justices from the Wisconsin Supreme Court in the case that somebody just asked about. I did not print the dissenting opinions. But still, that's quite a bit, and I've been focusing on our laws. My understanding, though, without having read this myself, my understanding from other people who have looked at it is that it's procedurally a different situation than what we have here. And so if that's true, then we're not going to get the court to say the same thing because it's brought to them in a totally different way. But we'll see. We'll see. And I'm still going to read this for you guys and try to answer questions about how that relates to what we're doing here. No matter what, though, a decision that comes out from the Supreme Court from the state of Wisconsin or the Supreme Court from the state of New York or California or Tennessee or Florida, those would be what is called persuasive authority. That's not binding authority. It's something that our Supreme Court can look at, but they're not bound to follow it. So just for what it's worth in answering that question. So I think that kind of answers the question about, does the Wisconsin decision that just came out this week help in Michigan here? It can help. It can provide basically an example of how to go down the path of correcting the situation So if our judges here or Supreme Court justices here are like, we don't really want to be the first to do this. I mean, that really shouldn't matter, but they are humans. So if they're not quite sure that they're thinking of handling it in the right way, and yet they can turn to the Wisconsin Supreme Court and read the decision there, it could help in that regard, but it's just not binding authority for us. I think that answers all of those. I do have to answer the license question, but are there any more? Okay. Why could the governor go to the 1945, well, the question was executive order. It's actually a 1945 act. MCL 10.31 through MCL 10.33 would be what you could look up on the Michigan Legislature website, instead of the newest one. So why could she? Well, she can't. That's what she's claiming she could do. But all the laws on the same point have to be read together. So when you have the law about emergency management, emergency powers being utilized in the state of Michigan, when you have that law or laws on that point in Chapter 10 of our statutes, those have to be read together with the laws on the same issue in Chapter 30 of our statutes. That's just how it happens. I think our statutes are a mess, but they're all a mess. I mean, we have, for example, in doing public defender work, when I was doing defense work as a public defender, and I had a client charged with a specific crime, I might need to look in, goodness, we have there's a provision of our laws that's called the Code of Criminal Procedure, and then there's also essentially another chapter of our laws that's called crimes. I don't remember exactly what the wording is, but it's not the procedural aspect so much as it is defining what crimes are. However, we have, I think it's called the I don't know what it's called, what the word is. It's not judicial act, but judicatory act or something like that anyway, it's chapter 600 of our statute. So MCL 600 point, and then there's a lot in there that, it's not all criminal stuff, but there's a lot of stuff that applies to criminal cases. So I might have one client with one situation, one act that was charged with something. Well, I need to look in that chapter of our laws that talks about criminal procedure. I need to look in that chapter of our laws that talks about the crimes in general. I need to look in that chapter of our laws, chapter 600, about the basically act about how court actions happen in general. I might need to look in other specific laws about driving offenses or licensing offenses or child abuse and neglect offenses. There's just a variety of things that might be outside of the scope of one of those three provisions on top of those three provisions. We also then have the complicated situation of, well, then we have court rules. I don't have a court rule book that within my reach, but essentially we have the state court rules are, the state court rules, there's a lot of them. And so just on criminal procedure alone, again, this is my example, right? We're talking about emergency powers. However, this is just the example. So criminal procedure here in our Michigan court rules, this is an old version, it's 2015, but it works for our purposes here, is chapter 6. So we have all these rules that come into play. And so these are not the statutes. You would cite these as MCR. So Michigan court rules. Whereas the laws are cited as MCL, Michigan Codified Law. So you have those that come into play. And then depending on other things and what we're talking about, you might have some laws or some procedural rules you need to follow from district court procedures, which is chapter 4, or general provisions, chapter 1, special actions and proceedings, chapter 3. So one incident, one action, one client could be charged with something that involves laws from all those different pieces. It might involve court rules, in all those different chapters. The whole point is, if it's illegal under one law, then it's illegal, even if you're looking at the other law. So it's here, the 1945 Act and the 1976 Act are not opposing each other. They don't say opposite things. One merely gives additional powers and additional specifications to the use of emergency powers by the governor, whereas the other is basically the first time that we've said, hey, we're going to go ahead and give you such a power, and here's our general idea about you using it. But the 1976 statute was like, they were like, hey, we need to give more specifics. We need to tell you, as the governor, what that looks like, how that plays into the legislature doing their job. How does that play into us as citizens having constitutional rights? So far, I don't think anybody has noted anywhere in these pleadings. I could be wrong. I have not read all 1,000 pages that has been filed in this Court of Claims case. The case with the legislature suing the governor. There's an insane amount of documents. I don't know if you can see my binder here. There's a lot here. This isn't everything. That's just what I asked for from the court, and you have to pay 50 cents a page. So, yeah, that was already expensive enough. I think I answered all of those. I'm going to give that back to you. But from what I have looked through, what I have heard from the oral arguments today, I don't think anybody has talked about MCL 30.421. So the long and short of it is, overall, it talks about this heightened state of alert. So we have a typical emergency where, hey, this is pretty bad. We need the governor to exercise more powers than she normally would. That's for that. But then we have this heightened state of alert under MCL 30.421, and that's saying there's something even more concerning. But even in that situation, we can't trample all over constitutional rights. We can't avoid the separation of powers that's guaranteed to us in the Constitution. So that law specifically says, make sure I'm going to quote this right, that, and it doesn't say this only applies to that subdivision, okay? So that, it says that the whole Emergency Management Act, right? So the governor's powers under this act, the whole thing, everything from MCL 3.401 through MCL 30.401 through MCL 30.421, the whole act, everything the governor does to exercise powers under that act shall be consistent with the provisions of the state constitution of 1963 and the federal constitution. So that doesn't just talk about the exercising of constitutional rights. Our constitutions also have provisions on restraining governmental exercises of authority. So, for example, Article 3, Section 2, that requires the separation of powers, that does not allow someone in the governor's seat to exercise the power of the judiciary or of the legislature. That's a constitutional provision that still has to be followed in the exercise of these emergency powers. But they went ahead and they explained a little bit more, saying that prosecutors cannot prosecute violations for executive orders. So in other words, Carl Menke, the barber from Owasso, who's being charged with, I believe it's 2 misdemeanors and 1 civil infraction for having his barber shop open. He's being charged with those because he's violating the executive orders to stay home. So prosecutors cannot, they are prohibited from prosecuting a case just like that in any, quote, manner that violates any constitutional provision. Okay. Also, prosecutors are further prohibited in prosecuting these violations of executive orders, like in the barber's case, from prosecuting, quote, conduct presumptively protected by the First Amendment to the Constitution of the United States. A lot of people just automatically assume it's free speech. Shoot, I have. Okay, we're going to read it. I mean, I know it's in there, but we're just going to read it. So, the First Amendment to the Constitution of the United States says that Congress shall make no law respecting an establishment of religion or prohibiting the free exercise of someone's religion, free exercise of religion, There can be no law to abridge the freedom of speech. There can be no law to abridge freedom of the press. There can be no law to prohibit the right of the people to peaceably assemble. There can be no law to prohibit the right of the people to petition the government for a redress of grievances. I think that's 4. Either that or I stopped counting right. I think that's actually 5 that I said. So that'd be 5. So all of those in there, the whole First Amendment, not just free speech. So what this is saying is that prosecutors cannot even prosecute a case. They can't even bring it to court for conduct that is presumptively protected by the First Amendment. So what does presumptive mean? Well, presumption, that means instead of a case being brought to court and the defendant is the one that has to argue the affirmative defense, they have to raise the defense on their own. It's their burden of proof, essentially, for a particular defense to be asserted. Here, this is saying there's a presumption. So when there's a presumption that conduct could fall within the First Amendment, then if it looks like it falls within the First Amendment, then it'd be the prosecutor's burden to show how it does not fall under the First Amendment. And if they could meet that burden, then they could potentially pursue prosecution for violating these executive orders, but only if the manner in which they're prosecuting does not violate any constitutional provision. Man, that is a huge hurdle. That is a huge hurdle. I hope some of you prosecuting attorneys that have been giving me grief over this letter really stop to think about that. So essentially what that means, so we have to consider that the main point of all these executive orders, according to the Attorney General herself, Dana Nessel, the main point of these executive orders is, quote, to keep people away from each other, end quote. That's the whole point of all of these executive orders, because they believe social distancing is required in these situations, and the 6 feet rule is not enough, and all the other medicine and data on point is not enough, and whatever else. That's a whole different story. Point is, the whole point is that to keep people away from each other. Okay, well, how are you going to meet that burden of proof as a prosecutor? Because how would you be able to ensure that someone is not exercising their right to peaceably assemble, to exercise their free speech, to exercise their religious, their religious beliefs, to get word out to the people about what's going on? So essentially, freedom of the press, to utilize any of those other rights guaranteed under the First Amendment, to petition a government for redress of grievances. So in other words, by effectively amending the Open Meetings Act and effectively amending the FOIA statutes, the Freedom of Information Act, she is curtailing the ability of people to petition their government for a redress of grievances. At any rate, there's so many constitutional violations here, it's not even funny. But those are some important points that kind of go into answering this. I'm doing a terrible job here. Is the governor criminally liable for any of her orders? Ooh, good point. So all I'm going to say is there's a whole bunch of things that could be on point for this. So 42 USC section 1983. I also believe, let's see, is it 18 USC section 241 and 242 would be on point. There's got to be more. Okay, there's got to be more. But I didn't even talk about those in here. But in this letter that I wrote to prosecuting attorneys, and sending it also to city attorneys, local law enforcement agencies, sheriff's departments, etc., I basically remind these individuals that every single attorney in the state of Michigan, every single public official, from a school board member or a downtown development authority board member, or the governor or the attorney general or anybody in between, all those public officials and all law enforcement, we take an oath of office. And that oath requires us to specifically uphold the Constitution of the United States and of the state of Michigan. So, okay, so you're violating your oath if you're not upholding the U.S. or Michigan constitutions. You're also then going outside of the scope of your governmental authority. Well, that's the whole point of this lawsuit, right? The governor has gone outside of the scope of the authority that she's allowed to exercise. So as far as being criminally liable, any public officer attempting to enforce these clearly unlawful, they're illegal and they're unconstitutional executive orders, I would argue they're guilty of malicious prosecution, which is something that in Michigan law, it's found as a common law action, but it's also found in our statutes. The statute on point would be MCL 600.2907. So there's that chapter 600 I mentioned earlier. Anyway, the malicious prosecution aspect can provide for civil or criminal, or civil and criminal liability. So I would argue the answer is yes to that question. Also, abuse of process would be found here, depending on the particular person, but I would argue certainly in the governor's case, because enforcement of these clearly unlawful executive orders and unconstitutional executive orders is not legitimate, it's not regular, it's not legal. So abuse of process, which is more of a common law claim, that would also be available too. So I think that answers that question. Someone asked, how is she able to enact another executive order when she herself terminated the original one and then there was no new virus or mutation or whatnot? Exactly. So as I pointed out somewhere else, essentially what she did, under Executive Order 2020-4, that's where she initially claimed the state of emergency. Executive Order 2020-33, she said, well, we still have a state of emergency, but now I'm going to call it a state of disaster too, which is not what the law allows, but it really didn't change anything. So then in Executive Order 2020-66, which she did, all these three that I'm going to talk about, on the 30th of April, she declared, it was a declaration that the state of emergency and the state of disaster are terminated, meaning it's over and COVID-19 can be managed in non-emergency ways. That is exactly what that termination did. Then in 67, Executive Order 67, 2020-67, she stated that the state of emergency, the one she just terminated, remained, meaning it continued. She terminated it, then it somehow remains. Then in Executive Order 68, she declared a state of emergency and state of disaster across Michigan, meaning it began. It's a declaration. It's found. It's now declared, right? So it's reduced to the point, it's terminated. It's reduced to the point that we can handle this in non-emergency ways. It is actually still around and it's just continuing. And, oh, it began. Again? It's the same thing. It's still COVID-19. So that is the exact point of why none of this makes any sense. That's more of the common sense perspective. And I believe that actually was something that was brought out by the judge herself. I think possibly Attorney Williams. But, okay, so that talks about that. Hopefully that question came after I answered the question about the Wisconsin. Okay, so yeah, there's a lot that Attorney Allen said that was not accurate. I don't mean offense to him, but it's just the case. You know, when he says that the two laws are not married, you know, they're not even complementary to each other. She could cherry pick. There is no law on point that allows her to cherry pick. At any rate. If this is true and clear, then how could the judge rule against it? Okay, so I think the question is getting at if the way I'm describing the law is this true and it's this clear and obvious, the way that for the most part, that attorney Michael Williams was arguing the case today. If it's that obvious, if it's that true, how could the judge rule against it? I mean, the answer to that is the same way that every day, not all, but some police act outside of the scope of their authority. Prosecutors prosecute people they know are innocent. Judges take bribes, or they have a bad day. They forget why they went into the legal profession in the first place. I don't know the specific answer to you other than sometimes it happens that people in every profession do the wrong thing and they violate their oath of office, or they violate their standard of care. They violate the law. That happens with judges, lawyers, doctors, teachers, everywhere. So hopefully that answers your question. Do I think that this judge will rule against the legislature's motion today? My best guess is no, she's not going to. I think her line of questioning made it very clear that she understands the law does not favor the governor here. The Constitution certainly does not favor the governor here, and immediate action must be taken. Are we open yet? Legally, yes! If you are just tuning in now and you haven't seen any of my other posts or any of my other videos or any of my documents, but yes, please, would you, if you own a business, can you please go open it now? And if you're doing shellac, if you do pedicures and manicures, could you please let me know if you're not too far away from the Grand Rapids area, because I would love to go there. I also get a haircut about once a year, and it's killing me. And my office is really hot right now, and I'm sweating, and it's primarily because, there's this hair and I don't spend a lot of time getting ready, so don't ever expect me to try to look like a movie star or anything. Not going to happen. But seriously, yes, please open. If you have a restaurant that you are just hearing this for the first time, that what the governor is doing is illegal and unconstitutional, and you're like, whoa, okay, awesome. I'm going to go ahead and open my restaurant. Please let me know. I want to come eat there. If you have a movie theater that you're opening, please let me know. I love movie theater popcorn with salt and butter like it's going out of style. I'll probably start gaining some more weight, but I need, to spoil myself a little bit, right? Seriously, if you own a business, please do open up. If you are just an individual who wants to go into Menards without a mask, by all means, please do so, because they don't have the right to stop you. There's a whole bunch of laws on point with that, but it's also a whole nother conversation. But we are open, and there's no emergency powers executive order, not a single one that has legal authority at this point. Not a single one. Every single thing the governor is trying to do, or every single executive order she's trying to enforce right now, every single one of them, it's like it doesn't exist, because legally it doesn't. Do I think this will stop her? Depends on who the her is. If we're talking about the governor, do I think that this, the hearing that happened today is going to stop her? I don't know. Probably not, to be honest with you. I think people just need to go about living their lives and following the law and the Constitution as it's written, because clearly our governor and our attorney general don't want to follow the law or the Constitution as they are written. And so just because a court tells them, hey, stop, you're doing the wrong thing, does that really mean that they're going to stop doing the wrong thing? They might stop doing that wrong thing, but I don't trust that they are going to, not start doing a different wrong thing. Like I mentioned before, I believe Attorney General Dana Nessel I believe she's very intelligent. I think she knows what she's doing. So that's kind of the scary part. I think she knows that she doesn't have the legal authority to do what she's doing, and yet she's doing it. So no, I don't think this will stop them. I think it's going to take people doing the right thing, judges doing the right thing, business owners doing the right thing, police and prosecutors doing the right thing. We all just need to be doing the right thing. Don't sit around, no matter who you are or what your position is, don't sit around and wait for other people to do the right thing. Just start doing the right thing on your own. I guess I'm the best example of that, because if I'm the only attorney that's been out in public putting my reputation on the line by standing on the steps of the Capitol twice now, explaining these legal provisions, that's totally outside of my comfort zone. And yet it's what needs to be done, right? My own family, not all, a big chunk, they they're not buying it. I'm going to try to figure out a nice way to say this. They do not look at the laws and the Constitution and think that's the law of the land, that's what we're going to follow, and that's it. They tend to think that I'm just being too political and too crazy, I guess, because I want to go against the grain. I'm going to go against the grain every single time if it's the right thing to do. I'm not here to make friends. I'm here to do the right thing. That's just how I live my life. Don't get me wrong, I love friends. But a friend is not a friend if they want you to do the wrong thing. And certainly if they're going to abandon you for standing up for principles. But at any rate, okay, hopefully that answers all of those. How can she turn off the Freedom of Information Act? The short answer, she cannot turn off the Freedom of Information Act. She cannot turn off the Open Meetings Act. And yet, twice now, because she's rescinded the original orders and then reissued the same ones, or maybe 3 times. I mean, she's done so many, I can't even keep track. But yeah, she's essentially tried to erase the Freedom of Information Act and the Open Meetings Act and has zero legal authority to do so, which is why there's already lawsuits pending about those exact provisions. Will she have any consequences for doing things she's not allowed to do? I sure hope so. I would think any attorney who steps that far outside of the bounds of what they're allowed to do under the law, any attorney, whether they're acting in their capacity as a governor, as an attorney general, as a prosecutor, but certainly someone who's like, say, the attorney general or the governor, if they're going to act that far outside of the scope of the law and of the Constitution and negatively impact the nearly 10 million people that live in the state of Michigan, curtailing the freedoms and rights of 10 million people, I would certainly hope that that might impact their ability to practice law here in the state of Michigan, that would mean they're going to be facing significant civil consequences as well as criminal. But can I guarantee that? No, I can't even guarantee we're going to be here tomorrow. I mean, Jesus might come this afternoon and we get to go home. Can I explain the difference between an applied challenge and a facial challenge? This was at the end of the hearing. Yeah, he actually, Michael Williams, the attorney for the legislature, actually referred to this at various times throughout the whole hearing, but there was a lot of dialogue back and forth, I think, towards the latter part of the hearing. So an as-applied challenge and a facial challenge. The difference is that, let's say the Emergency Powers Act, the Emergency Powers of Governor Act of 1945, if that is by itself, if it's unconstitutional on its face, that means no matter how a governor tries to exercise those powers, it's not constitutional. It's going to violate our rights. But if it's as applied, it means that the powers themselves a governor can certainly follow the language of the law and exercise those powers, but do so in a way that does not trample on our constitutional rights. So that would be what's happening here. He's saying, Attorney Michael Williams argued that the Emergency Powers of Governor Act, the 1945 Act, and the Emergency Management Act of 1976, that the provisions in general of both acts they're constitutional on their face. They're just, he's challenging as applied. So he's challenging how the governor has used these powers under the statute, not how the law actually allows her to use them. Hopefully that answers that question. What are the chances the governor wins the case? I'm going to defer to the big discussion I really gave on that earlier and all the reasons why I think the judge is going to rule the way that I think she's going to rule. So I did answer that. I just don't want to waste your time keeping you any longer. Why, if she asked the legislature to extend it once, realizing the need for their input, would she now try to do this on her own and without permission from the legislature? Yep, that's a good point. Why would she do that? Indeed, she asked them for an extension, and they gave her an extension. And then this second time, I actually don't think she even asked for an extension. I think she very clearly said she doesn't care what they do. She's just going to issue, a state of emergency to extend beyond April 30th, no matter what. So I think the second time around, she didn't even ask them for the extension. And she did that because, I don't know. She doesn't want to follow the law. What reason would she have for that? It's not a good reason. I mean, that's, I guess, the short answer. But it's a very good point that you're making. It doesn't make logical sense that she would recognize the need for the legislature to approve an extension the first time and then not the second time. Going to the Supreme Court. I'm not going to go into a ton of detail because I did answer that already, and I don't want to waste your time going over things too many times. But my guess is that this will go to the Michigan Supreme Court by the end of next week. Something will be filed in the Michigan Supreme Court because no matter who loses, they're most likely going to want to appeal and bring it to the Michigan Supreme Court. Is anyone filing a complaint with the Attorney Grievance Commission against Attorney General Nessel for her behavior in this shutdown? I don't know if any attorney has yet to file something like that. It actually doesn't take an attorney. Let me see. Yeah, no. Unless I haven't looked into this in probably 6 years, but I'm fairly confident that any person can file a grievance with the Attorney Grievance Commission for conduct by any attorney licensed in the state of Michigan. So if you believe that the governor has violated her professional conduct and her oath of office to uphold the U.S. Constitution and the Michigan Constitution, you can certainly file a complaint with the Attorney Grievance Commission. If you believe Attorney General Dana Nessel violated her oath of office, her professional code of conduct as an attorney, or specifically her oath of office, and has violated the Constitution of the United States or of the state of Michigan, you could also file a grievance against Attorney General Dana Nessel and the Attorney Grievance Commission. I guess I haven't been checking, but I'm not aware of anybody who's done that yet. If you know of one, if someone else knows of a complaint that's been filed, please let me know. We've heard she's extending the lockdown until July 29th. Again, she doesn't have legal authority to do that. She can do it all she wants. I'm pretty sure Dr. Janae Khaldun said in the recent press conferences that this issue is going to last throughout the entirety of 2020. So she certainly said on April 29th in the afternoon press conference, she said that this was only the mere beginning of addressing this whole COVID-19 crisis. Well, if they only think it's the beginning, clearly they're going to ramp up the amount of ways that they're intruding upon our constitutional and statutory rights. They're not gonna give them back. So I think that answers those. Oops. If I open my restaurant, will you represent me if the health department tries to shut me down? Where do we get a list of open businesses? Okay, so, and I think this other one is about licensing. Why are citizens supposed to wait for a judgment to revoke licenses or hand out tickets? Okay, so first of all, if you have a restaurant and you open and the health department in coordination with the Michigan Attorney General's office seeks to revoke your licenses, that would be totally illegal and unconstitutional on behalf of those governmental agencies. Now, are they doing it? Clearly, they're trying to do it to the barber in Owasso. It's not lawful. Unfortunately, at this point, I can't guarantee you, without even knowing who you are, I can't guarantee you that I would personally represent you, merely because if this fight is not over, and they're still allowed to do this to you, that means they're not allowed to do it. If they think they're allowed to do it to you, that means they think they're allowed to do it to everyone across the state, which means I need to continue to educate people across the whole state on what their rights are, what the law says, what the Constitution says, and empower people to recognize all political power is inherent in the people according to our own state constitution. I believe it's Article 1, Section 1. But we don't get our rights from the government. We don't get our right to run our business or to, to freely assemble, to worship, to speak freely. We don't get those rights from the government. We get those rights from our God, from God. We get them from God, and our state and our federal constitutions, they talk about that. In the preamble to the United States Constitution, it says, quote, "We the people secured the blessings of liberty to ourselves and to our posterity," end quote, by establishing the Constitution. And that's because those blessings of liberty, they're blessings, and by the way, capital B and capital L, blessings of liberty, okay? They're not given to us by the government, they're given to us by God. And that's what we had in mind here in Michigan. In our own Michigan Constitution, in our preamble, it says, quote, "We the people of the state of Michigan, grateful to Almighty God for the blessings of freedom and earnestly desiring to secure those blessings undiminished to ourselves and our posterity," end quote, established our state constitution of 1963. Don't sit around and wait for the government to say you have the permission to exercise these very freedoms. They didn't give them to you, and they cannot take them away. Has the government exercised unconstitutional restraints upon those freedoms throughout the country and throughout history? Yeah, definitely. There's definitely been Supreme Court decisions, United States Supreme Court decisions, state Supreme Court decisions, statutes and regulations. There's definitely a lot out there that currently does diminish those rights, but that doesn't mean that, well, we've allowed them to diminish this right over here, so we'll just have to keep allowing them to diminish our rights over here. If you want to do that, if you want to wait around and sit patiently waiting for the government to give you your rights that God gave you, I guess that's your choice. I'm going to ask you not to. I'm going to ask you to exercise those rights. So can I represent everyone or even one particular person? I can't promise you that right now, because I'm really hoping that there's some other attorneys across the state that feel this passionately about the oath of office, about their oath that they took when they swore in to practice law here in the state of Michigan to uphold the U.S. Constitution and the Constitution of the state of Michigan. I'm begging those attorneys to step forward